Good afternoon. Welcome and thank you for attending today's webinar, Important Changes to New York State Tenure and Teacher Discipline Laws. My name is Kathy Purdy and I will be the host for today's presentation. The presenters for today's webinar are Bethany Centrone, a school district law attorney in our Rochester, New York office, Richard Cass, a labor and employment law attorney and member of the school district practice group in our New York City office, Howard Miller, also a labor and employment law attorney from our Garden City office with a focus on education law, and Jeffrey Kell in our New York City office, who has been active in education law since 1974. Today's presenters will discuss the new requirements for probationary appointments for teachers and administrators, tenure recommendations, and discipline of tenured teachers and administrators. We ask that you enter your questions throughout the presentation in either the chat or question box located on the right-hand side of your screen in the GoToWebinar docking pane. Our presenters will answer questions throughout the presentation. This session is being recorded and will be made available to all attendees within the next 2 to 3 days. And one last item before we begin our presentation is to ask that you take a moment and complete our survey at the conclusion of the webinar. Again, welcome to today's webinar, and I'd like to introduce you to Bethany Centrone.
Good afternoon, everyone. Thank you for joining us. So today we're going to talk about some of the changes that were included in the 2016 budget, including the probationary period and tenure law changes and the changes to discipline of tenured faculty. In a nutshell, the probationary period and granting of tenure changes basically increased the length of the probationary periods. It sets requirements for granting of tenure, and thankfully for school districts, also has secured that unfettered right to end probationary periods and to grant and to deny tenure that we all used to have before APPR and 3012C. In the discipline of tenured faculty, also some positive changes for school districts. We have some increased transparency for school districts and 3028 procedures that we didn't have before. Presumptions with regards to incompetency related to ineffective ratings have been strengthened, but the statute is now requiring us to take action in certain circumstances that we'll talk about. So we'll start with probationary periods. For all appointments that are made on or after July 1st of 2015, we will have a new length of probationary periods and some new requirements. And these lengths of probationary periods will apply to all teachers and administrators, not just those that are evaluated under 3012D now or C in the past, but there are differences with regards to what has to be done for APPR evaluated staff and non-APPR evaluated staff. So first question that we ask is, when is a teacher or administrator appointed? Now, this language is not part of the statute, and we look to the Commissioner's decisions to give us guidance on that. There is a lot of guidance with regards to appointment date related to seniority ties, and in those decisions, appointment date equals the date of the Board of Education resolution. And we've provided you with a reference to a Commissioner's decision on that topic. Last week, thankfully, the Commissioner's Office did confirm that for purposes of the new probationary periods, the Board of Education resolution date is the appointment date for the longer probationary periods to apply. So our recommendation to those districts that want to take advantage of those longer probationary periods is that you hold off on making appointments to the extent possible until July 1st. So what are the new probationary periods? We have the same categories of probationary appointments that we had in the past. Administrative positions, new teachers, i.e. those being teachers who have not had prior tenure in another district or in your district. Teachers with prior tenure, and those teachers who have had regular substitute teaching service within your district prior to being appointed. Essentially what the law does is increase each of those categories of probationary periods by 1 year. Administrative positions all will be 4 years starting with July 1st. New teacher appointments, again, 4 years. Teachers with prior tenure with a caveat for classroom teachers will be 3 years, and teachers with regular substitute service will be as short as 2 years, again with caveats for classroom teachers. Because for classroom teachers, they must be APPR evaluated in order to be able to receive that prior credit. And we may want to pause here also to talk about what has been required for the actual probationary period appointments. When making a teaching appointment, it is required that the resolutions have the tenure area of appointment, the dates of the probationary period, and the certification areas of the teacher being appointed. And I think many of the resolutions that I've seen have forgotten that certification area piece, but those are required to be there. And for administrative appointments, this is even more essential. It's not a requirement under the regulations or the statutes that that those elements be there, but if you don't indicate an appropriate tenure area, you will not. You will have difficulties later on with regards to reductions and with regards to tenure.
Bethany, is this a good point to jump in?
Sure, go ahead.
This is Jeff Kale speaking. This is really a good time for all of us when we're talking about appointments to think about what we do in terms of appointments. Now, as Bethany explained to you, when we all first looked at the new statute and we saw appointed prior to or after July 1, our first question was, well, is that starting service or appointments? Our assumption was that there was going to be a difference and that it's the date of appointment rather than the date of start of service, and the State Education Department has confirmed that. I think Bethany's point about the appointments resolutions for teachers is critical. It's Regents Rule 30-1.3, and what we do find is that as time goes by, that tends to get more honored in the breach and the observance. It's a very good time to look back. And when we look at the administrator appointments, which Bethany also mentioned, we had a very vivid wake-up call from the acting commissioner this April 2nd. It's a decision you can look up. It's on the web. It's number 16,731. And this is really a central administrator's worst nightmare. In the East Ramapo School District, they hired 2 people to be elementary assistant principals rather, and when they were appointed as assistant principals. They were assigned to elementary schools. They always worked in elementary schools. When they received tenure, the school district apparently caught up to it and tenured them as elementary assistant principals. But then a few years later, when economic constraints came along, the school district eliminated all of its elementary AP and some but not all of its secondary assistant principal positions. And the 2 displaced elementary assistant principals, having longer terms of service than the secondary school assistant principals, claimed that they had been improperly laid off and that they were entitled to the positions. And in that April 2nd decision, Acting Commissioner Berlin ruled for the 2 administrators. And she said that it doesn't matter that there was an attempt retroactively to correct it when those probationary periods were first appointed as assistant principal. That's the tenure area they were in. So we really do have to redouble our attention to how we make administrative appointments so we don't get hit by the law of unintended consequences. Now, Bethany mentioned you might want to make this year's appointment after July 1 in order to take advantage of the longer periods. Of course, most school districts have already made some appointments for next year, and those are going to be 3-year tenure, subject to foreshortening for prior tenure or Durima credit. I think we have to ask ourselves, both in practical terms, what we might lose by not making appointments until late in terms of candidates who might go elsewhere, and also, quite frankly, since as Bethany mentioned, it's going to be the appointment date which breaks ties on start dates for seniority, give some thought to how that might impact you in terms of when you make those appointments. And that's a pretty real consideration because many of our districts have demographic change, which is going to result in reduced enrollments. We're all staring at problems with the tax cap. Layoffs have not left us. Bethany, all yours.
Okay, thank you, Jeff. So this comes to our first big question of the day is how are we going to determine if the shorter probationary periods apply, both with regard to the prior tenure and with regard to DREAMA credit. And just a reminder that these are not cumulative rules. You get one or the other with regards to credit. So let's first talk about shortened probationary periods for prior tenure. Again, this will shorten the new probationary period from 4 to 3 years. So if a teacher has had prior tenure in your or another district and was evaluated under APPR in the final year of service in that prior district, they would be entitled to the shorter probationary period. Of course, this only applies to classroom teachers, not teachers who would not normally be evaluated under 3012C or 3012D. But we need to think about those teachers who are on assignment or in instructional support services who were not classroom teachers prior to coming to your districts or in your districts, other non-classroom teachers who may be coming into a new role. This happens frequently with, for example, special education teachers or reading teachers that have different certifications or multiple certifications and may change tenure areas. And one question that will have to be answered is that what's the final year of service if a teacher is changing tenure areas within their own district, especially when you think about the fact that there may be a teacher who had prior tenure, went on an assignment role, isn't evaluated under APPR, and now is changing tenure areas. But in any case, what we recommend for school districts is that you revise your hiring process and applications and hiring documents to make sure that you're asking about APPR evaluation and that you require applicants to submit copies of their last evaluation when they are seeking credit for prior tenure. And here comes the harder part, DREAMA credit or shortened probationary periods with regards to regular substitute service. Currently, the current requirements come from commissioner's decisions. These have not changed, so you must have an appointment that's in regular substitute service that's in the same same tenure area as your probationary appointment.
Well, Bethany,
are you seeing that? Oh, go ahead. All right.
While we wait for the slides to catch up, there are a couple of troubling things which this statute doesn't really answer yet, and Bethany raised that in terms of the APPR evaluation, and that's going to be, I think, particularly tricky with regular subs. But there's also another question to which we really don't know the answer yet, and I'll give you a concrete example. Let's say, for example, that your school district has an Italian teacher who was properly appointed to before 2015 to the foreign language tenure area. She also happens to have the ESL certification, but you didn't appoint her as an ESL teacher. And 2 years from now, once we're past the effective date of the new statute, you eliminate your Italian program. And for whatever reason, either lack of interest on her part, lack of certification, or she's the most junior teacher, you don't have a foreign language position to offer. But you do have an ESL position, and you're happy to offer her a new probationary period, which we all do all the time. Is that probationary period going to be under the 4-year probationary statute or under the 3-year? Because she's been appointed twice. She was first appointed before the new statute. Her next appointment will be after the new statute. And while if she had tenure at the time of the transfer, she might be entitled to some foreshortening for having had previous tenure in district, that wouldn't be the case, let's say, if she was still probationary. The short answer is we don't know, and the even shorter answer is we're going to find out if we're wrong when that teacher claims tenure by estoppel. So I think our practical recommendation here, which goes to the point we all know, you have to keep an accurate tickler system. Assume in that teacher's case that it is the shorter period which will apply and make your decision then. You're going to have a lot of freedom to do that. You can obviously discharge a probationary teacher mid-appointment for any and all of the same reasons you could deny tenure. When we're in this transitional zone, let's make sure that we take a look. And by the way, if you go back far enough, I don't think we're going to find any guidance on this. There was a point in the very early 70s when New York State went from 5-year to 3-year teacher tenure. And you would have thought that perhaps there'd be some transitional decisions as to that. But when that happened, which was about 1971, we didn't have any of the Part 30 tenure areas because those didn't come into existence till August 1st, 1975. So we're really charting new territory here. If you're not sure, pick the shorter period and make a note so that you're sure it pops up in your tickler.
And then if you're not sure when the shorter period comes into play, you could always make a dual agreement with that teacher and extend the probationary period ad hoc that way. But usually 2 or 3 years is enough to know whether this is someone who is probably going to get tenure or someone who you don't want to have tenure. So to go safe the way Jeff is suggesting really has no downside to it.
And now we seem to have caught the slides up to the presentation.
So the JREMA credit issue, I think, is even more complicated than the discussion that we're having. Again, the appointment must be in the same tenure area as the regular substitute service. The substitute service had to be full-time, had to be long-term, at least a full term or more, had to be continuous service, no breaks in between substitute appointments, and it must have been immediately preceding the probationary period. There's a new statutory requirement that classroom teachers must have been evaluated under APPR in each of those years that they're requesting or seeking credit for the shortened probationary period.
Now, by the way, this suggests an interesting approach to getting longer probationary periods where you have teachers who would otherwise get JREMA credit, which is just don't evaluate them under APPR, and then they'll be ineligible. And by the way, as to those who are not supposed to be evaluated under APPR, it's clearly the longer period. However, one of the things I did was I pulled State Ed's most recent guidance, which is April 24th of this year, on APPR review, and for better or for worse, it doesn't have anything to do with the new statute. It's all the old existing APPR that we know and love. And actually, as to a lot of those regular substitute teachers, we were supposed to be evaluating them under APPR standards if they were teaching in the classroom service and serving as the teacher of record. So to the extent that you've had people in that position, if we had the duty to evaluate them under APPR, I think we will have to assume that the shorter period should have applied.
Right. So these the probationary periods, again, only affect, the longer probationary periods and requirements only affect teachers who were appointed on or after July 1st, 2015. But as Jeff mentioned, some potential issues that arise, that some districts may not currently be evaluating substitutes, and that the guidance was changed in the second or third iteration to require that regular substitutes who are teachers of record needed to be evaluated. Some districts might not have changed that practice. You know, I know from my prior life as an HR administrator in a large school district that we would constantly be barraged with complaints from the unions if we were evaluating substitute teachers. You know, also, the decisional law allows for credit for less than a year of service. It's a full term. Obviously, teachers who start in September and are appointed to a probationary appointment in February are not going to be evaluated. Frequently, it's difficult to start to evaluate teachers who start in mid-year, even if they're starting on or prior to the beginning of the second semester. And this raises the tenure by estoppel issues. What happens when we have a teacher who had regular substitute service prior to their appointment should have been evaluated under APPR and wasn't? We could assume that they will not get tenure by estoppel and we don't have to worry about those things because the law is clear that unless they have those evaluations, they will not be granted tenure or granted the shorter probationary period. But then we have grievances that might crop up either if you have a unionized substitute workforce, or as those teachers are appointed to probationary appointments and fall under the regular union agreement. But we recommend that districts work now, if they haven't already, to establish systems to capture their substitutes who they believe will or may hit the JREMA credit threshold. And we have to recall that we might not always know at the beginning of a substitute service that would happen. Many teachers extend their leaves. They were sick. They didn't get better. They were on parental leave. They decided not to come back. And therefore, it's certainly possible that someone who we thought was going to be a substitute for a month or two is now a substitute for 3/4 of the year and would potentially get this JREMA credit. In my prior life, we set the rule of thumb if we expected a teacher to be a regular substitute for at least 3 months. We started the evaluation process for them just in case it was necessary, and also just in case they needed to be identified as a teacher of record for APPR purposes.
Now remember in this regard, for JREMA credit to apply, and Bethany mentioned this, it has to immediately precede a probationary appointment. You can teach as a regular substitute for 10 years, and if you don't get a probationary appointment, JREMA credit is never triggered. It has to be full-time, and it has to be in the same tenure area as the subsequent probationary appointment. With all of that said, Bethany's point that decisional JREMA credit includes periods of less than a year as long as it's more than a semester creates a loophole. If you've been in this business for any length of time, you know that both teachers and our friends at NYSUS will look to any ambiguities and to any potentially questionable practice to get the best deal possible for the teacher. So once again, in calculating tenure periods, when in doubt, go out short.
Right. And also, remember that what you're calling a teacher isn't necessarily controlling over what they're doing. Just because you call somebody a per diem, if they're working in a regular substitute position for a full term or more, and then they're appointed, they would still be entitled to this credit. So you need to really make sure that you're capturing those teachers.
One other point we might make here is, because this comes up from time to time, you will have a teacher go out, let's say, on parenting leave in September. It's a full year leave, but by April, she lets you know, you know what, I want to let you know now, I'm not coming back. Many school districts have filled that April to June period with an interim or regular substitute appointment, the idea being that you'll make the full-time appointment for the next year. Bear in mind, please, you technically cannot do that. The education law abhors a vacuum, and when a regular sub-appointment can only be made to an encumbered position. If the position is not encumbered, you must make a probationary appointment, which you can then, of course, later terminate for pretty much unfettered reasons. But as of April, the person whom you hired into that job is a probationer, for better or for worse.
Great segue, Jeff. Because now we're going to talk about the probationary period, and one of the good things for school districts that is in the new law is the revitalization of the unfettered right to terminate teachers in the probationary period or to deny tenure at the end of the probationary period. Specifically, and the language of the statute is on the slide that is on the screen now, hopefully. Thankfully, they have deleted the language that would prohibit school districts and boards from terminating probationary teachers based upon performance during the probationary period because of the requirement that you needed APPR scores to do that, and also have indicated that performance is a legitimate reason expressly for the termination of a probationary teacher without reference to APPR. In fact, the statute now specifically states that terminations can be can be made pending an APPR appeal. As in previous, we would have to wait for an appeal to be processed before we would be able to make performance-related terminations of probationary teachers. So that's a good removal of a lot of ambiguity that's been in the law. It only took 3 times for the legislature to change it so that we could be back in the place that we were there before, but thankfully they've done that.
Yeah. I think one issue that's going to come up with this new change is whether it has retroactive effect. What happens to a teacher who was fired during this past school year before an APPR was issued? Even under the old law, it was unclear exactly what a school district could do with regard to a teacher in that situation. So I think this could be argued both ways. I think some people might say this is a clarification of what came before. Some people might say this is a change and it's only prospective. So there may be litigation on that issue as well.
Which is an interesting point, because I think the elephant in the room on APPR so far has been that I believe we've all pretty much been ignoring APPR and making retention decisions as to probationary teachers. And I would like to think that this new amendment reifies that decision. But Richard is right. Some creative person is going to come along and make the argument that the change from A to B must mean that A had more effect than we gave us.
Right. And the other thing that I think some school districts have been doing even in the past before the law was changed is saying, well, we're going to fire you because of your classroom performance. We're going to assume that you would have done wonderfully on the APPR. We're taking that into account. That's part of our considerations. But even given that, we still want to fire you for such and such reason. Mm-hmm. I don't think there's been any court case that's been asked to rule on that, but I think that would still be a pretty good argument even under the old law.
And just one more thing about terminating probationary teachers. I mean, typically we would rather have them resign than have us make a public record of them being fired. But for those who won't, and they are entitled by statute to request the reasons for their termination, one thing that sometimes happens with schools is when they give the reasons in writing, those reasons don't necessarily match up to what has been said in prior evaluations. So you need to make sure that the reasons are actually going to be in conformity to the deficiencies you've seen, either in an evaluation or in a counseling memo and the like.
Very good point, Howard, because let's also remind everybody, as a matter of law, a school district is free to deny tenure for any reason or for no reason, so long as you don't trench on statutory or constitutional rights. That said, Education Law Section 3031 gives the teacher the right to demand a statement of reasons and gives you the obligation to reply. There hasn't been much case law on that lately, but the case law that does exist is quite consistent. The reason has to be a reason. And I can tell you that I think all of us have had more than one heated discussion with the Board of Education in which we try to explain insufficiently excellent doesn't cut it as a reason, because there are rulings on that point. So that being the case, I think it underscores Howard's point. The reason you give is going to have to be consistent with otherwise observed facts with respect to that teacher. Otherwise, you're going to look pretty silly, and it may even be a basis for reversal.
With that being said, while our ability to terminate probationary teachers for any reason or no reason at all, as long as it's not discriminatory or violation of constitutional rights, we're not going to be as free as we were to grant tenure, at least for classroom teachers and principals who were appointed on or after July 1st, 2015. Those faculty members will have to receive an effective or highly effective APPR rating in at least 3 of their probationary years, and they cannot receive an ineffective rating in the final probationary year, although the statute specifically carves out that for those teachers or principals that do receive an ineffective in their final year, an extension agreement can be granted. Now, extension agreements, dual agreements, that, as we all know them to be called, are a creature of case law, not usually a creature of statute, and this is the first time that we've seen a statutory authority to enter into extension agreements. But our second big question is what happens for a school district that has a teacher that they think is a good teacher and for whatever reason are not getting the effective ratings on assessments, especially with a lot of the challenges to assessments that are being raised these days, and they do not receive the effective ratings. How many extension agreements can we give them before they get effective ratings? Enough effective ratings to be able to move forward. Can we give them more than one? Are we going to be able to give them during for teachers who haven't had 3 effective or highly effective ratings during their probationary period? Are they only now available to those teachers who had ineffective in their 3rd year? These are questions that aren't quite answered by the statute because of the interplay between the new language in the statute and what we've always been able to do under decisional law.
Well, we will be seeing more of it for the very reasons Bethany has stated. And this might actually be a good time to take a look at those so-called jewel letters, which some of us call additional probationary year letters. And there's 2 things I want to point out about that. When we do that, at least our practice has been, our jewel letters have a very explicit statement of the rights that the teacher is giving up. They basically say, I understand that I have the right to have a tenure decision made now. I understand that I'm not obligated to extend this. I understand, I understand, I understand. There is a new wrinkle in the ointment, and our friends in the Western tier are going to know this better than some of our others because it's a 4th Department decision. There was a decision about 2 years ago. A teacher signed a dual agreement, got her additional probationary year, was denied tenure, and then came up with the very novel argument to the court, my dual agreement wasn't approved by the Board of Education. Ipso facto, it was invalid because it required board action to validate it, and therefore I have tenure by estoppel. And the court's answer was quite interesting. The court said, well, teacher's right. This was a non-delegable board prerogative. You can't have superintendents just willy-nilly going forward and extending people. So the agreement was invalid. At the same time, the letter had agreement in which the teacher said she waives her right to a claim of tenure by estoppel, so we're not going to let her break her word now. She's out of a job.
Yep.
That case hasn't caught on in any other departments, but one of the things we have started adding to those letters, because you really don't want to humiliate one of your faculty members if you think they're good enough to give them another year, in addition to waiving claims to tenure by estoppel and all sorts of other good lawyer stuff like that, we're saying, I'm also requesting you, Mr. and Ms. Superintendent, please not to have the Board of Education make a formal public resolution of this, and at the same time we're suggesting to superintendents, make sure your boards at least knew about it. So far that's worked pretty well, but as long as that case is out there, it's probably worth considering.
You have to say I've become so fond of dual agreements over the years that I basically sleep with one under my pillow. And it's something that is an important tool to have when you think you have somebody good, but you're just not quite sure. So when you do them, you just want to make sure they're done properly.
The other thing, again, in my prior life, not as a lawyer, but as an administrator, we changed our resolutions, our probationary appointment resolutions, to specifically authorize the superintendent to extend the probationary appointment. So in the probationary appointments, it says that it's up to 3-year or as extended by the superintendent.
In fact, there was a case in the 2nd Department that considered that issue about whether it's a matter of contract between the superintendent and the teacher, or whether the school board really does have to approve the way the 4th Department said. In the case that Jeff was mentioning, the 2nd Department really didn't come up with a clear decision on that, but I think that's still an open issue about whether the 4th Department really was right that school boards have to approve that. But just as we were saying before, the probationary period, safety is always the best policy. At least there's some courts out there saying that the school board has to approve the dual agreement. So either that has to be done or some sort of workaround has to be made the way Bethany was indicating.
And by the way, pending further clarification, if your board does want to accept the example Bethany gave, which gives the superintendent some discretion from the get-go to extend a probationary appointment. Remember, it's a bedrock principle of the dual agreement that the teacher has to agree to it.
Right.
I don't think that any board action can confer a unilateral right on the superintendent to extend a probationary period unless the incumbent agrees. Now, we've just had that happen for our friends in the Southern Tier. You've seen this. We've had a blanket FOIL request from a local Westchester newspaper wanting to know how many people got denied tenure over the last, I think it's 5 years. And the short answer to it is almost nobody, because they all resign. However, we are going to come up with that teacher who won't resign, and we need to be squeaky clean when that case comes up.
Absolutely.
Of course, we have a whole lot of leverage when we ask someone to sign a dual agreement, because the alternative is termination. So usually they agree.
So someone asked the question, why would we not want the Board of Education to approve a dual agreement? And basically, I think, I can't remember, somebody mentioned it quickly, most faculty members, and especially administrators, do not want a public acknowledgement that they were not going to be granted tenure to go onto board resolution. It's embarrassing for them. So when you're at that point in time where you're trying to offer an extension and working things out with a teacher or administrator who's on the cusp, the fact that that might be publicly displayed affects the decision of those people as to whether to stay or to go or to fight about why they're not getting tenure.
Yeah, if I can add to that, I think in at least 9 out of 10 cases, no superintendent offers a dual agreement unless he or she thinks that the candidate has a reasonable shot of getting tenure if there's another year to season the person. If you start with that assumption and you then hang them out to dry in public as having been found to be unworthy of a tenure appointment, you're kind of stacking the deck against them, and it's a rather unpleasant public spectacle.
And I'm going to throw this out to my colleagues. You know, whether if you are going to have the board adopt it, if you could have the resolution read instead of approving and adopting a stipulation of agreement between the district and Mrs. or Mr. So-and-so, it could just say a member of the teacher's bargaining unit.
Or employee number 2018-1, which is what we do when we do Section 75.
Now, a member of the public could foil that, but if it was in a consent agenda, I'm not sure who's going to really go in and notice that.
No, you have different reporters on there than we have up here.
Well, we have some people who like to certainly foil everything that's ever been done in a school, but at least there would be more of a shot to protect the privacy of the teacher.
Let me just add one more thing about dual agreements. Despite what Howard said about his sleeping habit, we have to be careful not to overuse dual agreements. They have to be particularized to the particular teacher. There was a school district on Long Island several years ago that tried to force every probationer to extend his or her probationary period. That was struck down by the courts because that was seen as a way of trying to circumvent the law. So there has to be a particularized reason for every extension of a probationary period beyond what's required by the law.
Yes, and if you remember the case law, and not all of you have been around long enough to remember this, when we were worried about tenure areas in terms of layoffs and school districts were doing very ingenious things, they thought, to try to get the broadest possible tenure areas, the courts ruled in a number of cases public bodies really should not try to act in derogation of the policies behind tenure laws. So if you were to assume that the legislature has ordained that tenure should be granted or denied after 3 years or now 4 years, if you make it a regular practice to try to get around that, I think you're going to walk exactly into the buzzsaw that Richard mentioned.
Mm-hmm. So let's talk about what happens after teachers and administrators are granted tenure, and we no longer want them to be with us. So the changes to the statutes, there has been some changes to education law, Section 3020A, that are positive for districts in some ways, and also the addition of education law, Section 3020B. Section 3020A now will apply for discipline for misconduct, just as it does now, and discipline for incompetency that is not based upon consecutive and effective APPR ratings, whereas Education Law Section 3020B will be reserved for discipline based upon consecutive and effective APPR ratings for classroom teachers and building principals. So let's talk about Section 3020A first. Changes to the current law. The first big change is the status of the faculty member pending the disciplinary hearing. As we all know, one of the biggest expenses associated with 3020A processes and disciplining faculty is the time that those faculty members stay out on paid leave. The statute now allows for unpaid suspensions for charges filed on or after July 1st, 2015 for teachers or administrators who are being charged with the physical or sexual abuse of a student. Previously, unpaid suspension was allowed only when there was a conviction of a drug-related offense or conviction of a felony crime related to the physical abuse of a minor or a student. So this allows us to not have to wait for that conviction to occur before we can move forward. There will be a requirement that there's a probable cause hearing. If school districts do want to suspend without pay, that's going to have to occur within 10 days of the decision to suspend without pay, and there will be an expedited hearing process for teachers suspended without pay that is supposed to be completed in 60 days. All in all, teachers aren't going to be allowed to remain out on unpaid suspension for more than 120 days, but presumably the process, 3020A process, will be done by then.
Just one thing that shouldn't get lost in the shuffle of 3020A is that you do have obligations under Part 83 to report what could be deemed immoral conduct to the state, and the state has really started to take that very seriously, and notwithstanding any discipline that may be meted out in the 3020A process or failed to be meted out in the 3020A process, the state may, on its own initiative, where there has been serious misconduct, do a Part 83 hearing and not just terminate, which would not just result in the termination of the particular employment, but of the revocation of the teacher's license. So that's an obligation that you really ought to make sure that you're following carefully.
And to restore your faith in human nature, we found those Part 83 hearings to mete out some pretty tough penalties and a lot of license revocations. Bear in mind, like the old tenure panels, the old 3020A panels, those were tripartite panels which have a teacher representative on them. It is absolutely amazing what a different set of assumptions a union president brings to one of these hearings when he's addressing the profession and not one of his own unit members and his own duty of fair representation. We're getting a lot of union hanging judgments.
And again, you're seeing this more with certainly abuse of children, and academic dishonesty is something that the state is taking very seriously.
Absolutely. I would say that I've had situations where a 3020A hearing was not successful, mainly because of access to evidence was not available to the school district. But then when it went to a Part 83 hearing, the state was able to access evidence not accessible to the district and successfully revoked certification. So those Part 83 complaints are very important. Additional changes to 3020A, there will no longer be panel hearings as of July 1st, 2015, or for charges brought on or after July 1st, 2015. Again, it used to be that charges of pedagogical incompetence, not based upon with the expedited process that was under 3012C. Previously, teachers were able to select a 3-panel hearing. Now all hearings are before a single hearing officer. Additional changes. Hallelujah, school districts are at least now going to get some pre-hearing disclosure from teachers. As you might know, before now, districts were always required to provide full and complete disclosure of all of their evidence and discovery for the teachers, but the teachers or administrators were not required to give any information to the districts. This is would be created much more of a problem in situations where faculty was being disciplined for misconduct that occurred off campus or outside of school, where they would not be able to access the information internally. Now, hearing officers are required to set a schedule and manner for full and fair disclosure of the witnesses and evidence to be offered by the employee. That's not a perfect resolution. If the teacher is not, or a principal is not going to be presenting the evidence, we wouldn't have access to it still, but at least we have something before the hearing starts to know where the hearing might go. Just post-hearing changes to 3020A. We've all been in a situation, I'm sure, where we've won the war, or won the battle but lost the war, where we've proven all of our evidence, and we've proven all of our charges, and the hearing officer just wouldn't terminate. Now, statute specifically requires that the hearing officers, although they still have discretion with regards to penalty, they must give, quote, serious consideration to the board's recommended penalty. And if they don't accept the recommended penalty, they will have to articulate, based upon the record and in the decision, why they did not accept that penalty.
And that sounds very nice. I don't think it's going to have any practical difference at all, because any hearing officer worth his or her salt is going to be able to make some sort of noises that sound like an explanation for why he's choosing one penalty rather than the other. But I guess it doesn't hurt.
And it may give us some basis for review.
Yeah, if the hearing officer makes a mistake and fails to put in that sentence in his decision, then yes, it may create a basis for review.
So now, in addition to the changes under 3020A, we now have a new 3020B, which are the streamlined procedures that will apply when there is going to be discipline based upon consecutive ineffective APPR ratings. And there are two levels of this. Where there are two ineffective ratings, school districts and boards may file charges against a teacher for incompetency. And if there are three consecutive ineffective ratings, boards and school districts must file charges of incompetency. And these are not, this is not dependent on appointment dates. 3012C and APPR has been around for several years. So teachers or administrators appointed prior to July 1st, 2015 would be subject to the same disciplinary procedure if they had consecutive ineffective ratings. There are other requirements that will be under 3020B. This is an odd requirement, which hopefully will be clarified in the regulations, but the charges must be based upon events occurring within 3 years of the date of the charges. Now, if we're filing charges based upon three consecutive ineffective evaluations, that first evaluation is necessarily longer than 3 years ago. So hopefully there'll be some clarification in the regulations, possibly the determination of incompetency after the second ineffective or after the third ineffective is really what the charge is based on, not on the actual evaluation, but we'll have to get some clarification on that. Additionally, the statute requires that the recommended penalty for charges filed under 3020B be termination. And that goes back to the hearing officer, the language in the statute in 3020A that says that hearing officers must give serious consideration to the recommended penalty. If charges are brought based upon two consecutive ineffective ratings, they must allege that an improvement plan was developed and substantially implemented. There's a different hearing process with the 2 years of ineffective as opposed to 3 years. And if you're basing charges on 2 years of ineffective service, the parties, the school district and the union, can mutually select a hearing officer, or they have the opportunity to do that. The hearing process cannot take longer than 90 days. And the presumption of incompetence based on the due to ineffective ratings can be overcome only by, quote, clear and convincing evidence that the employee is not incompetent. Interestingly, it doesn't say anything about whether the tip was implemented or developed, as although you have to allege that it was, that's not in the language with regards to what the presumption would be. If you have 3 years of ineffective service and the board is required to bring charges, SED will select the hearing officer for us. The hearing process is to take no longer than 30 days, and the presumption of incompetence will be overcome only by clear and convincing evidence that the calculation of one or more of the employee's underlying components on the APPR was fraudulent. The only definition of fraudulent that's in the statute currently is that it includes misidentification. It does not spell out any other areas of fraud. Potentially the regulations that will accompany this will give us more examples. And the statute provides that for both 2 consecutive ineffectives and 3 consecutive ineffectives, that termination must be the penalty absent, quote, extraordinary circumstances.
Our firm was fortunate to have, I think, what's the only case under the old expedited 3028 procedure, which was in effect just this past year for the first time. And under the only decision that I'm aware of in that case, the arbitrator was asked to hold that there was a presumption of incompetence based on the 2 consecutive ineffectives. He wasn't willing to go that far, but he was willing to say that, that together with testimony from the evaluating administrators supporting the ratings, then it could be create a presumption of incompetence. So this goes a step further than the only interpretation of the previous expedited law. One thing that I think there are 2 places where these supposed improvements in the procedure really are a step backward from the district's point of view. First of all, when the SED selects the hearing officer, that is very dangerous because we don't know what kind of hearing officer SED might appoint. We've had some experiences where they've appointed people, when the parties have been unable to from the AAA list, where SED has appointed people who are not very good hearing officers, let us say.
Let's try horrifyingly incapable.
Yeah, well, something else, though, is that under the new regulations, there's a grid that shows how the student performance and other parts of the APPR ratings are to be balanced.
This is the heady checkerboard.
The heady checkerboard, right. And under that, if that checkerboard were in effect last year, we would not have been able to win the case that we won last year under the previous expedited 3028 law. So it's difficult because what we had in that case is a teacher who did absolutely terribly in her teacher observations, but she did quite well in the other aspects of her APPR. Under the rating system that was negotiated for that school district, she came overall and ineffective. But under the new system, overall, that teacher would have been developing, and we wouldn't have been able to go ahead with the expedited 3020A or now 3020B procedure. So the legislature did do school districts some favors in how it improved the law in some respects, but there were some other respects in which this is actually be less favorable to the school district, more favorable to the incompetent teacher than it had been before.
Which I think, as we are now up to the question period, brings us to 2 observations, if I may. The first one, which is unrelated, is that Richard Howard and I would really like to thank Bethany for having pulled this together, because she's done 99 44% of the work. The other thing is, you may have noticed that there is something we did not address here, although it is certainly a 500-pound gorilla. What are we going to have to bargain with our faculties as to what goes into this? What are the weightings going to be for the APPR factors that go into the heady checkerboard? Are our obligations on this going to be deferred past November 15, 2015? And are any of our districts which can legitimately be claimed either to be high performing or to have better ideas going to be excused from some of the aspects of what feeds into this? And the short answer to all of that is we don't know yet. We'll let you know when we do. But I want to make one practical observation. For those districts to which that supplemental tranche of state aid is going to be important for making your budgets, just remember, if you're in negotiations this year, don't make any commitments dependent upon that money until you know you have an APPR agreement with your faculty which has been approved by state aid. Bethany, are we ready for questions?
We are. The only thing I would point out that we would still have the 3020A process for those teachers that aren't being terminated based upon the ineffective ratings, but who we think are incompetent overall. You know, it's longer and more. It'll be longer and more complicated, but I think this isn't a death knell to terminating teachers who are developing for 5 or 10 years in a row, if that's how long they last. So we are ready for questions.
You know, although you can anticipate in those cases where the teachers union would say, well, there's a very highly developed procedure for determining who's ineffective and who's incompetent. If you haven't fallen into that definition, then there could be a presumption of competence.
Right. And I think we would argue that if they're not, they certainly aren't effective if they've been developing for that period of time. So it'll be an interesting time for us to try to figure out how to maneuver through the new processes. Who wants to answer the first question?
We can't see them, Bethany, so why don't you read them to us?
Okay. Kathy, you want to read them out loud? Yeah.
The first question is, why wouldn't you want the Board of Education to approve the JUUL?
Yeah, I think we answered that one before.
And then the next question was in reference to, yes.
I think that there was a question about suspensions during with pay or without pay during if there's a 3020B charges are brought, and yes, they would be with the suspensions during that process would be with pay. So the only time that there would be suspensions without pay under the new law would be if a teacher or an administrator were charged with sexual or physical abuse of a student, or under the old law, if they were convicted of sexual or physical abuse of a minor or a student, or were convicted of a drug-related crime. Now,
well, convicted will fly. Accused, I think, is going to present some constitutional issues and will probably be subject to challenge. If you remember the Court of Appeals case which established the right to suspension with pay during the pendency of a 3020A proceeding, which was Jerry versus Soda, I believe. That was really grounded in the underlying constitutional principle, which is the bedrock of 3020A, that tenure represents property interest from which someone cannot be divested without constitutional Fifth Amendment due process. So I'm quite confident that that one's going to be litigated when it first comes up.
Yeah. Well, hopefully the procedures for the probable cause hearing will help with that. And certainly if someone is found not guilty of the charges, all that time would be repaid to them. I think if anybody has any questions lingering, now's the time to type them in.
Yep, we have a couple more minutes left.
I want to add, while we're waiting, that there's one other issue that came up in the context of that other expedited case that we had under the now superseded law. And that is, in the 3020A for incompetence, can the teacher relitigate how fair the APPR rating was? Every APPR procedure has to have an appeal procedure in it. And so if a teacher has already gone through the APPR procedure that's been collectively bargained, can that be revisited during the 3020A? In the case that we had, NICE had argued, yes, it could be revisited. Our APPR appeal procedure specifically stated that it's the exclusive avenue to appeal an APPR rating. And the arbitrator that we had in that case agreed that it can't be challenged as long as the procedure is fair on its face. So that's something that as we're negotiating APPR procedures under the new law, we want to make sure that when you talk about the appeal process, that the appeal process explicitly state that it's the exclusive avenue to appeal an APPR rating. That will help certainly to expedite your 3020B hearings.
Absolutely. Anything?
Okay, if we have no more questions, this will conclude today's webinar. I'd like to thank all of our presenters, and I invite all of our attendees to contact any of them. Their contact information is there on the last slide. Just one more time to remind you to take a moment and complete our quick survey at the conclusion. So thank you everyone for attending, and have a great afternoon.